Okay. All right, you back on the record with them too? All right, well, it's okay. We're back on the record now with 20S00357FY, people of the state of Michigan versus Christopher Stuckey for preliminary examination. All right, we took a brief recess in order to handle a couple of short items. And so now we're ready for the exam here. And so, Ms. King-Coleman, is there any other preliminary matter that we need to address?
Nothing from the people, Judge.
And from the defense?
Your Honor, just a motion to sequester any and all witnesses who will be testifying in this matter.
All right, and so I think we only have one, but is that true or not? Because if so, if we have more than one, we'll go off the live feed and that will sequester it.
Well, has Mr. Officer Boone called in?
No.
So it will just be one witness, Judge.
Do you think he's going to be calling in? Did you have some contact? Because I'll go off the live feed if he is.
Okay, I have a text message out to Detective Rada, who has not responded at this point, but did confirm that Officer Boone was notified of the hearing and that he would be present today.
All right, well, we'll go off the live feed just in case. And for anyone that wants to watch this exam, we will post the exam later after we finish everything. We'll upload it out to YouTube, so it could be available for the public. But we have to go off the live feed in case there's witnesses that are also watching the live feed and listening to what the other witnesses are saying. Okay, all right. So we're off the live feed right now. All right, so call your first witness.
The people called Jared Weebeck.
All right, Mr. Weebeck will be coming in momentarily. Jason, it's Jared Jason.
Yeah. Hello.
All right, sir.
Yep.
What is your name?
Jared Weebeck.
All right, and raise your right hand to take an oath, sir. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, can you please spell your name for the record?
Yes. Jarred. Jason, Jason. Weebeck, Wiebeck.
Okay, and so correct the spelling of his name, please. Jarred, please. Okay, Ms. King-Coleman, whenever you're ready.
Good morning, Mr. Weebeck.
Good morning.
Let me first ask you, do you have any documents in front of you?
Do I have any documents in front of me?
Correct.
I got the instructions for the Zoom meeting.
Do you have anything else, a police report or statements or anything like that in front of you?
Not directly in front of me, no.
Thank you. Can you please state your name for the record?
My name is Jared Weebeck.
And I'd like to draw your attention to April 14th, 2020. What were you doing that day?
I was working in my apartment.
And where's your apartment located? What's the name of your apartment? Okay. And what floor do you live on in that apartment?
First floor.
How long have you lived there?
I've lived in the apartment for 10 years, but this particular apartment for 7. I was up on the 5th floor previously.
And you said you were working that day. And did anything unusual occur while you were working?
Yes, somewhere around 5-ish, well, a little bit before 5. I heard,
PM,
I'm sorry,
AM or PM?
PM,
Okay,
a
go
little
ahead.
bit before 5 p.m. I heard some very excessively loud music playing from the parking lot outside my apartment. It was so loud that my windows in my apartment were vibrating.
Okay. And when you heard that loud music, what did you do?
I made the decision on whether or not to call security or go out and find out who was playing the music really loud. And so then I proceeded to go out and, because it was middle of the day, you know, go out and find out who was playing the music and see if they would turn the music down.
Did you call security as well at that point?
No, I didn't call security until after the incident where Mr. Stuckey pulled the knife on me.
Okay. And so you made the decision to go investigate, see where the music was coming from. What happened next?
I stood out there. Mr. Stuckey in his car, sitting there, drinking a beer, smoking looked like a cigar type tobacco product, singing to the music.
And how do you know this person, Mr. Stuckey?
I don't know him at all. The only reason I know his name now is from the incident.
Okay, so you didn't know his name before?
No, I
Okay.
had no clue, nor had ever seen him.
So can you just tell us, describe what you observed when you went outside to the parking lot?
So I went out, I saw him sitting in his car. I saw him with his eyes closed singing the music. And I stood there about 3 to 4 feet from his car and waited for him to look up and see me standing there.
Were his windows up, or were the windows on the vehicle up or down?
They were up,
What kind of vehicle was it?
like a crossover type vehicle.
Okay. And the person you saw in the vehicle, do you see that person in the proceedings today?
I see myself, I see Chuck, I see, well, hold on, yes, I do see him now.
Okay. And can you please describe an article of clothing that he's wearing?
Here he was wearing a white button-down shirt. It looks like he's got a beard and a mustache.
Okay. Your Honor, let the record reflect the identification of the defendant in these proceedings.
So ordered.
Thank you. Had you ever seen Mr. Stuckey before that day?
No,
Okay. And so when you went out to the parking lot, what happened after that?
I stood there. He finally looked up at me. He rolled his eyes, closed his eyes, went back to singing for a bit. A few seconds, maybe 20, 30 seconds. Then he looked back up again at me. He rolled the window down and said, "What the fuck do you want?" At that point, I said, "Hey man, I live right here on the first floor. I'm just asking you to turn your music down." He goes, "I live here too." And he told me to shut the fuck up. And he said I was trying to oppress him. And then he broke out his cell phone and tried to start filming it. I felt that he was trying to turn it into something like a racial incident because he was saying that I was trying to press him and he was trying to get it on.
Objection as to what he's speculating the Mr. Stuckey is thinking.
Yeah, it's the same. All right, sir, just tell us what you know, not what you think he meant. Okay, so go ahead. What's the next question?
Are you talking to me or?
No.
You need to ask a question to stop the narrative. We don't want it to be a full narrative. So go ahead and ask questions.
Okay. And so how far away from the vehicle were you at this point?
roughly 4 feet, 3 to 4 feet away.
Okay. And so what happened after he asked, what the fuck do you want? What happened after that?
I told him that I wanted him to turn the music down. I said, hey, can you turn the music down? I'm trying to work. And he said, nobody's working at 5 o'clock or whatever, this late in the day. And I said, I am. And we, you know, he was insulting to me. And I told him that he doesn't know how to spell oppression.
So when you said he was insulting, what do you mean by that?
You know, telling me to fuck off and saying other stuff like that.
And what happened next?
Then he reached over into the passenger seat of his vehicle and grabbed a folding knife.
So can you describe the knife that you saw?
It was kind of like a shiny metallic knife that kind of had like a rainbow feature, you know, where you changes color depending on what direction the light is hitting it at. And it had a blade of approximately 3 to 5 inches.
So you said it was a folding knife. When you saw it, was it folded or unfolded?
When he pulled it out, it was unfolded. He unfolded the knife.
So you saw him unfold the knife?
Yes.
Okay. And where were you at this point when you first saw the knife?
I was standing in the same place that I was, which was about 3 to 4 feet outside of away from his car on the driver's side.
And was the window down still at this point?
No, he went from the window down to he had opened up the car door at that point.
So at the time when you saw the knife, the car door was open?
Yes.
And Mr. Stuckey opened the door?
Yes.
Okay. And did he make any movements toward you at this point?
Up until that point, you know, he kind of like turned towards me, still sitting in the car, but he was turned facing me a little bit.
Did he have the knife in his hand at that point?
Yeah.
Did he say anything when he pulled the knife out?
Yeah, he said, get the fuck away from me or I'm going to fuck you up. And then he got out of the car and took 2 steps towards me and said, you better, you know, I'm going to fuck you up. And I said, you know, at that point in time, when he got out of the car, I'd already backed up a few more feet. So I was probably about 6 to 7 feet away from him. And then I said, listen, man, I'm calling the cops on you. And I backed up till I felt I was a safe enough distance away, and then turned around and walked into my apartment. And then I proceeded to call the police. And then I called the apartment security at that point.
Okay, so did he make any gestures with the knife at all?
He held it in front of him, pointed at me at about somewhere between his belly button and his chest.
And was the blade unfolded or folded at that time?
Yes, it was unfolded.
And so you said you took some steps back. Why did you take those steps back?
Make sure that there was distance between us, to the point where if I needed to, you know, turn and run, that I could do so without having him be able to close that distance real quick.
So were you afraid that he was going to cut you with the knife?
Cut me, stab me, harm me in some fashion with the knife, yes.
And you testified that defendant said that he was going to, quote, fuck you up. What do you think he meant by that?
I felt that he was meant to cause great bodily harm to me in some fashion or another.
And did he say anything else to you?
Did he say anything else?
Yes.
After he threatened me?
Yes.
No.
Okay. Did he say anything else besides he was going to fuck you up?
No.
Okay.
Not at that point. When he was outside of his vehicle and he had the knife in front of me, so I'm gonna fuck you up. That was it. You know, I turned around and started, going back into my apartment.
Okay. And what did you do when you went back into your apartment?
Like I said before, I immediately got on my phone and called the police and called security.
And did the police arrive?
Yes. I think security got up there before the police did. And then the police got here.
The Southfield Police Department?
Yeah.
Okay. And did you go back outside when the police arrived?
Did I go back outside? Not right away. I was in the hallway talking to the police, and that was it. I didn't go outside of the building.
Did you give a statement to the police?
Yes.
Okay. And do you have any knowledge of whether Mr. Stuckey was arrested on that day?
I believe he was. I also told the police that they should grab his camera on his phone.
Hold on 1 second, just answer the question.
Okay.
And your apartment is located in the city of Southfield
Yes, ma'am.
in Oakland County?
Yep.
Okay. I have no further questions at this time, Judge.
All right, cross-examination.
I can't hear. He's muted.
Mr. Webeck, can you hear me now?
I sure can.
All right, thank you. You indicated that during the time that you lived in the apartment, you never known Mr. Stuckey, have you not?
That's correct.
You didn't even know his name until the police report was made, am I correct?
That's correct.
You indicated that on the date in question that you walked out to the vehicle where Mr. Stuckey was seated, am I right?
Correct.
What did you have on?
Shorts and a t-shirt, sandals, I believe.
Did you have your hands in your pockets?
No.
When you indicated you were about 3 to 4 feet from the door, am I correct?
Yes.
And how tall are you, Mr. Webeck?
About 5'7".
You said he was sitting in a crossover type vehicle. Is it a tall vehicle or is it kind of a shorter vehicle?
Shorter crossover.
So you were able to see in the interior of the vehicle?
Yes.
Did you ever touch the vehicle at all?
Not in any way, shape, or form.
Because you were still about 4 feet away, am I correct?
Correct.
And you were 4 feet away at all times, am I right?
I never was closer than 4 feet away.
And you indicated you even backed up further to about 5 to 6 or 7 feet away, am I right?
That statement's not exactly. It's kind of hard to answer that question the way you phrased it.
Let me rephrase that question. You indicated that when Mr. Stuckey came out of the vehicle, you backed up even further. Am I right?
That is correct. After he came out of the vehicle, I backed away even further.
Indicated that Mr. Stuckey had the knife at what part of his body?
Well, when he first pulled the knife out, it was, he was sitting in the car. So it was, right in front of his chest. And then when he got out of the vehicle, it was somewhere between his chest and his belly button, mid-torso, I would say.
So when you see him you saw him actually grab the knife from the passenger seat, am I correct?
I did.
The knife was closed at that time, am I right?
He unfolded it. He grabbed it, he picked it up, then it unfolded it.
When you see him unfolded, do you back away even further from the vehicle?
I took a few steps back.
So when he opens the door, you're not in any distance from the door when he opens it, am I right?
He opened it before he pulled the knife.
Okay. So he opens the door and then he pulls the knife out.
Correct.
The knife is open at this time.
He opens the door, then he pulls the knife and opened it. The knife.
When he opens up the knife at this time, is the knife pointed up, down, or where's the knife pointed toward?
He would have had it in his right hand. And at that point in time, when he turned towards me, it was kind of in my general direction.
But I'm asking you, where was the knife blade pointing? Is it pointing
In my
towards the
general
ground?
direction.
I'm not asking you your general direction, Mr. Webeck. I'm asking you a direct question. Is it pointed up? If you know, if you don't know, Mr. Webeck, you can say, hey, I can't remember, or I don't know. But if you can remember, Mr. Webeck, tell me whether or not the knife blade was pointed up, down, or towards the ground, or do you know?
I don't. The way you're answering the question is not exactly an accurate portrayal of.
You can't ask me a question, Mr. Webeck. I'm asking you.
I'm not
a simple
asking you.
question. You're not what?
I'm saying that he turned in the car to the point where he was facing my direction with the knife in my direction.
I'm asking you a simple question, Mr. Webeck. Is the blade of the knife pointed towards the ground? Is it pointed up? Is it pointed towards you, or do you know?
Yes, it was pointed towards me, which is what I just said. He pointed it in my general direction towards me.
Okay. So the blade is pointed towards you.
Yes.
That's what I need to know. And at this point in time, you're about, what, 7 feet away, 6, 7 feet away?
About 5 to 6 feet away.
Okay. He doesn't lunge towards you, does he?
No, he didn't lunge.
Does he run towards you to stab you?
No.
Does he swing the knife at you?
No.
Do you know what happens with the knife, Mr. Webeck, before you turn and walk back into the apartment?
Do I know what happened to it? No.
Yes. Thank you, Mr. Webeck. I have no further questions.
Any follow-up questions, Ms. King Coleman?
Yes, just briefly. Mr. Webeck, when the defendant got out of the car, did he make any movements toward you at all?
Yes. He took several steps towards me and said he was going to fuck me up.
And what did you do in response to him taking steps toward you?
Backed up.
And had you not backed up, how close would he have been to you when he took those steps toward you?
If I hadn't backed up, he would have been within 3 feet from me.
Okay. And approximately how tall is the defendant relative to how tall you are?
I think he's close to 6 foot,
Okay.
give or take a couple of inches.
I have no further questions, Judge.
All right, that'll conclude this witness testimony on this issue. Let me see. I think that's your only witness.
Okay, Judge.
As far as this part of the exam is concerned, are you resting at
The
this
people
point?
rest. I have no further witness.
Mr. Toussaint, did you have any witnesses for the exam?
Your Honor, we have no witnesses at the exam. We rest as well.
Okay, and so for purposes of the bind over, did you want to make a motion and argument?
Yes, Judge. The people have proven by Mr. Webeck's testimony that by a probable cause standard that a felonious assault occurred and that this defendant committed the felonious assault, and the people moved toward the bond defendant over Ash charge and I reserve any argument for rebuttal.
Okay, Mr. Toussaint, any argument?
Your Honor, based upon the testimony of Mr. Webeck, I think what we have is a brandishing of a weapon. Mr. Webeck was never in distance of being stabbed or being, there was no swinging motion of the knife. There's nothing that would indicate that Mr. Stuckey was going to use this knife. I asked Mr. Webeck, there is a brandishing of the knife to show Mr. Webeck can, get the bug back, but there was, I would indicate, Your Honor, even at this probable cause standard, the prosecution has failed to show a felonious assault, and they have shown a brandishing of.
Well, let me ask you a question. If we just had him sitting in the car, open a knife, maybe. What do I do with the fact that he turns towards Mr. Webeck, pointing the knife, then gets out of the car, pointing the knife, he says, between his middle torso at him, walks towards him, and then says, I'm gonna fuck you up. That's showing no possible intent that he meant to maybe use the knife or injure Mr. Webeck. It wouldn't cause a reasonable person to fear or apprehend a battery.
I'll defer to the court.
Okay. Did you want to add, Ms. King Coleman?
Judge, it sounds like the issue is that the defendant had the ability to commit a battery and appeared to have the ability, as indicated, the defendant took the knife, opened the knife, made these threats, opened the car door, took steps towards Mr. Webeck, but Mr. Webeck had to step back to protect himself or out of fear of apprehension that he would be stabbed. So Judge, the people do believe that the elements have been met by a probable cause standard and ask that the court find the defendant over.
All right, well, the court agrees with the prosecution on this argument because we don't have to prove this matter beyond a reasonable doubt, Mr. Stuckey. This is not a trial. This is a probable cause hearing. And so the people have to provide evidence on each element of the crime, not whether or not it was accurate, but do they have enough where a reasonable jury could possibly find guilt. And so the elements of this crime of felonious assault or assault with a dangerous weapon are that the defendant either attempted to commit a battery on Mr. Webeck or did an act that would cause a reasonable person to fear or apprehend an immediate battery. And a battery is a forceful or violent touching of a person or something closely connected with the person. So the first element is, was an act done that would cause a reasonable person to fear an immediate battery? And the evidence was that a knife was grabbed out of the vehicle while sitting in the vehicle. It was flipped open. You turned towards Mr. Webeck, pointed a knife at him, and said to him, as you opened the door and got out of the car, and pointed it at him, get out of my way or I'm gonna fuck you up, basically, or something to that extent. That is an act that a reasonable trier of fact could conclude that would put a person in the reasonable apprehension or fear of a battery. The next element of the crime is that the defendant intended to injure Mr. Webeck or to make him fear immediate battery. Well, I don't understand why the words would be spoken, I'm gonna fuck you up, if there was no question that there was some kind of possible intent to injure. The words themselves give the impression that there is an intent to injure. Third element is, at the time, the defendant had the ability to commit the battery. I don't think there's any question that there was an ability because there was a knife in hand and the defendant was about 4 feet from Mr. Weeback and started to approach him closer, and the testimony was that if he hadn't backed up, he would have been within 3 feet of him. So there was an ability to either commit the battery, or there was the thought that the defendant had the ability to commit the battery. Can be inferred from that whole scenario. The last element is that the assault was committed with a dangerous weapon. The testimony was that the defendant had a folding knife, and a knife in and of itself can be considered to be a dangerous weapon, especially when used or purported to be used in that manner. And in this manner, the weapon may not have been dangerous at first when it was folded up, but certainly once it was opened up and a threat was arguably made, certainly that fits the definition of dangerous weapon, which is any object. It doesn't even have to be a knife, but any object used in a way that is likely to cause serious physical injury or death. And Mr. Weeback testified that he believed that if he didn't move, that there would be some kind of serious physical injury, or he used the words great bodily harm to me in some manner. So based upon the totality of the testimony, the court believes that people have proven each of the elements of the crime of felonious assault or assault with a dangerous weapon by a probable cause standard, and that the matter should be bound over for a jury to consider whether or not this has been proven beyond a reasonable doubt. All right, and so now we will move forward to the bond argument, as the court will bind this matter over as charged here in the complaint and warrant.
Thank you, Judge.
All right, so the bond motion is a motion for bond based upon the fact that there was an allegation, at least in the brief, that says that Mr. Stuckey just could not stay away from Mr. Weeback during the course of the pendency of this matter. And I can take judicial notice of my file that the defendant had a $15,000 personal bond with some conditions, and the conditions were pretrial services supervision, have no contact with Mr. Weeback, do not assault, harass, or intimidate him, beat him, molest him, wound, or threaten him, or any other witnesses. Don't go to do not possess any weapons or firearms. So that was the bond condition. And your motion apparently states that apparently on August 29th, there was some kind of incident that occurred over there, and Mr. Weeback apparently, and I'll let you all back this up, but the motion says Mr. Weeback was sitting in his apartment and smelled smoke, looked out to the hallway, found a smoldering cigarette in the carpet, went to security, talked to somebody who then looked into it with the camera system, and supposedly it showed the defendant intentionally putting a lit cigarette outside of Mr. Weeback's door, which caused the smoldering and the burning, which arguably is a violation of the pretrial release by even going close to the apartment. So that's your argument, Ms. King-Coleman?
Correct.
Mr. Toussaint, you want some testimony on this?
Your Honor, there is a video. Ms. Coleman showed it to me. King Coleman showed it to me today. I think she plays it for the court. Video speaks for itself.
All right. Well, so Ms. King-Coleman, did you want to play the video? Need to play the video? It seems like the defense is kind of capitulating that there is a video that it does show Mr. Stuckey flicking the cigarette over outside of the witness's apartment, contrary to the order not to even go over on that floor.
No, Judge, I don't see a need unless the court wants to see the video. If Mr. Toussaint is stipulating the video.
Your Honor, I think the court can view the video. I think it's probably important for everyone here, Mr. Weeback and Mr. Stuckey, to actually see this video.
All right, who has the video?
I do.
All right, you're gonna share your screen with us?
Yeah.
Okay.
There are two videos actually.
Okay.
Okay, one moment. Can the screen be seen?
Yep.
Yes, Your Honor.
Mr. Webeck, you live here. Can you describe, do you want any testimony or do you want me to play the video, Judge?
I'd like to just see the video.
I'm talking to the judge.
Oh,
It's up to you. It's your bond motion. I would take testimony since you got a video, yeah.
Mr. Webeck, can you describe what we're seeing here?
you're seeing the hallway right outside my apartment, facing, if you look down the camera, down the hallway, that's the lobby at the opposite end of from where the camera is. The side door is right behind where the camera is. And there is an apartment just to the left of where that exit sign is that you see at the top of on the ceiling. Actually, there's one right below where the apartment, right below the camera. So my apartment is the direct focus of like this video camera.
Okay.
On the left or right?
On the left, it's
Okay. So it's the one that's across from a door that has a mat in front of it?
correct, Your Honor.
And what is your apartment number?
107,
And on what date did this incident occur?
8/29. I believe it was a Saturday.
So August 29th, 2020?
Yep.
About what time?
Oh, roughly 7 o'clock
PM or AM, sir?
p.m.
Judge, do I need to replay that back? Did you see anything?
Yeah, no, you need to replay it.
Do you see that light spot that just fell to the floor? Do you see that?
Yes. Yes, I do. It looked like it rolled right up to the door.
It was about 3 to 4 inches from my door.
Yeah.
I'm gonna fast forward just a couple of minutes to 27:25.
Man, this is all.
Mr. Webeck, what are we viewing right now?
You're viewing me finding that cigarette out there. Previously, my girlfriend had put her head out the hall and saw that there was a smoldering cigarette. So I opened up the door and I saw the cigarette and it was still moist with saliva. And then right after this, I walked outside and threw it outside the apartment complex.
What happened to cause you or your girlfriend to open the door?
Smelled a smell of burning, and I didn't know where it was coming from. So we searched the entire apartment. I couldn't find any source of heat or electrical burning in my apartment, so I asked her to poke her head out in the hall and see if maybe like somebody was smoking in the hallway or a neighbor's apartment was having an issue. And then that's when she found the cigarette. And then that's when I came out And as you saw there, I picked up the cigarette from the ground.
I'd like to ask one question. Was the carpet burning in any way, shape, or form?
There was only about an inch of cigarette that had been smoldering in there. So it wasn't smoldering for very long. And there was a small little burn test in the carpet.
Judge, I have one other video to play from a different view.
Okay, go ahead.
As you can see from the timestamp, Judge, on this video, it's the same day. This is on a different floor, however. And this is the individual wearing the same clothes, talking in the same manner, same ponytail, same facial hair as we observed flicking the cigarette.
Yeah, okay, that looks like the defendant.
That's it, Judge.
Okay. Did you have any questions, witness, Mr. Toussaint?
I just have a few questions. Mr. Webeck, do you know which floor Mr. Stuckey stays on?
He never told me what floor he's on.
Okay. When you walk into the building, do you have to pass by your apartment to get to other floors in the building?
Not in any way, shape, or form.
So going in through the first floor, it would only be for first floor residents?
No, there's down by the lobby, there's a common area where the mailboxes are. And
let me stop you there. Are the mailboxes for everyone in the building or just everyone on the first floor?
Everyone in the building.
Are the elevators in the building as well to take you up to other floors in the building?
Yes, right by the mailbox.
Okay, and that's all on the first floor as well?
Yep. Plus, there's a stairwell right next to the elevators. There's absolutely zero reason for him to go by my apartment.
Let me ask you this. Is there a stairwell outside of the apartments themselves so you can go outside and not even come into the building?
Like a fire escape? Is that what you're asking?
Okay, no, I'm just asking, is there any other, there's no, you have to come into the building to go upstairs, am I correct?
Yeah, you have to come in the building, but you don't have to come onto the floor. So right outside the first view where the camera was,
Yes.
where you saw me picking up the cigarette and him throwing the cigarette down, right behind that is a stairwell. It goes up to the 6th floor, 7th floor, 5th floor. Every floor is accessible from there. So he can go into that door, go up the stairs without having to go by my apartment.
Okay. Well, I want to know. Thank you.
Can I say something, Vince?
I wouldn't suggest you say a word, but if you want to talk to your lawyer about that, you want him to say something, you can.
Okay, I wanted to address the whole video, how he came in apparently after I threw a receipt down or whatever it was. That was not no lit cigarette. I ain't wasn't even smoking in the building, first of all. Second of all, whatever came out my pocket, it wasn't directed towards his house. He came in after, looked down and said it was a fire. He kept saying there was a fire and it was smoking, and he sent his girl outside. When he came outside and looked, none of his story is matching up.
None of your stories seem to be matching up either.
Ma'am, there's no way I will go. I'm sorry. I apologize, Your Honor. I
would say do not say anything else, Mr. Stuckey.
Yes, sir.
Let him keep talking.
No,
I apologize.
Because this video was not a receipt. It wasn't a paper. It didn't drop like a paper, which would kind of float. It went down and it rolled.
It wasn't a lit cigarette.
Well, first of all, we're missing the whole point here. You weren't supposed to be on that floor at all. To even, if you weren't on that floor, there would be no issue with a cigarette, piece of paper, or nothing. You
Ma'am,
weren't supposed to be.
the only reason I was on that floor is because in our building we having technical problems with our key fobs. These notices has been up on the building for a month now. I couldn't get in but anyway but that door. You'll see I've been getting in that door all week, all month. If you look at all the cameras, that's the door that's been open. That's the door that let people in. I had company and we was going up the elevator. That's the only reason I came in that door. The front door won't let me in.
Judge, on Zoom, you cannot, unfortunately, tell your client what to do and can't do because, unfortunately, on Zoom, everyone has their say.
I'm sorry.
I would indicate to Mr. Stuckey, do not say anything else.
Mr. Webeck, what do you know about the key fob system in the building?
I use all the doors. So behind where the lobby is, on the same side of the building where my apartment complex is, there's the trash bins. I've used my fob on that. I use my fob on the front door. I use my fob on the door that I go in. You know, he and I basically would go in and out of the same door, which is the side door behind the video camera. He's got no reason to come by my apartment. If he needs to go get his mail, all he has to do is walk down the hall, the stairwell, by the elevator, or go take the elevator down to the first floor and get his mail and go back up that way. There's absolutely zero need for him to walk in front of my apartment.
Mm-hmm.
Judge, whether the key fob was working or not working, we all saw that there was a lit object that left Mr. Stuckey and rolled toward Mr. Webeck's door. Just a few minutes later, you saw another party walk by and noticed it on the ground. That person didn't say anything. Mr. Webeck testified that he and his girlfriend were in the apartment at the time, smelled smoke. Just a couple of minutes later, opened the door and there was a lit cigarette. Nobody else threw anything or dropped anything by the door. The only person that walked by the door was Mr. Stuckey. The testimony is consistent. It's a direct violation of his bond not to harass, contact, or go to Mr. Webeck's door. Therefore, Your Honor, we ask that the court find that defendant has violated his bond, and at a minimum, we ask that you increase the bond or revoke the bond. But I leave it to the court's discretion. But this is a clear violation of the bond condition.
Okay, Mr. Toussaint, what would you like to say?
Your Honor, I don't think that you should revoke the bond. I think right now, if this court were to place a teller on Mr. Stuckey, that you could possibly know where Mr. Stuckey is at all times and where he's at all times. It does seem to indicate in the apartment complex itself, there is a viable video system, and Mr. Webeck's floor is being videoed. Mr. Webeck's door is being videoed. Mr. Stuckey understands that he cannot go by his apartment, even though if he's in the same building. We have a problem here that both of the individuals live in the same building. Mr. Stuckey should not be going by Mr. Webeck's apartment at any point. So I would request, Your Honor, that don't revoke the bond, and if you want, place a teller upon Mr. Stuckey.
Judge, I would also add that Mr. Stuckey's actions were not only a danger to Mr. Webeck, but a danger for everybody who was in that building. Had Mr. Webeck not been at home and the cigarette would have caught fire, who knows what kind of flammable things are in the carpet. But if Mr. Webeck would not have been home, the entire apartment building could have potentially burned down. So Mr. Stuckey's actions were a danger to the public as well.
I agree with that. No question about it. this whole case is petty. The whole case is petty. And now we see the actions after the case are equally as petty. This was a simple situation that just got out of control for no reason. Loud, bumping music is offensive to people. And it's no harm to ask somebody, can you please turn it down? Everybody knows people are working from home. So and it's not an unreasonable request. So we got this situation that just kind of escalated to something that it didn't have to be with a knife. Okay? You would think that would be enough. But now we have this situation. Mr. Stuckey, you make your own situation worse. The court told you not to go near his apartment. There's no reason to have walked down that hall. Your key fob worked or didn't work. What difference does it make? You came in that door, why didn't you go straight up the steps that were right behind that exit sign and not walk past his apartment? Could have gone straight up the steps to the second floor, walk down the second floor and down if you needed to go to the lobby. There's no reason to walk by there. And from what Mr. Weeback says, the key fob system was working. So you could have gone through the front door. And if you had to go through that door, you sure could have gone in a different direction. And apparently there were steps down there by the lobby. The elevators were working. There's no allegation the elevators weren't working. So it would have been very easy to get from a higher floor down to the first floor to get to your mailbox or anything else you needed to do in the building without going by his apartment. And then to add insult to injury, see, nobody would have probably even realized that you had walked by the apartment had you not dropped the lit object, which you say was not a lit object, which it doesn't appear that that's accurate. It was a lit cigarette that you casually dropped as you went. And I'm not understanding what the point of that was. To try to start a fire, hurt this gentleman more because he said something to you about some noise and you didn't like it? You obviously didn't like it because you pulled a knife. But now, since he called the police, you want to set the whole building on fire. Not endanger him, but yourself and your apartment is in the same building. And any children and anybody else, older people who can't get out of their apartment quick enough, all of these people were at risk because of this behavior. And what for? What do you get out of this? It makes no sense. I can't condone this. Your story doesn't make any good sense to me whatsoever. That it was a piece of paper, it wasn't lit. We watched the video. It was no major length of time here. You dropped the cigarette or the lit object, and within a few minutes, someone saw it, looked down, kept walking, and then another person, Mr. Stuckey, smells it burning. It's that's how people die in house fires all the time. They are smoking the lit cigarette, which people think is not a big deal, is a big deal because it catches carpeting and everything on fire. And the next thing you know, you got a 3-alarm, 4-alarm, 5-alarm fire, and people are dying. Not to mention the property destruction for no good reason. So the court can't condone this kind of activity. It's a violation of our court order. And the court, you leave me no choice in this matter but to do something about this. You know, I'm not going to snatch your bond and remand you to the custody, but I'm going to increase the bond and I'm going to put a tether on you to make sure that you do not walk past this apartment. So the new bond conditions are as such. Yes, there's going to be pretrial services, supervision. Yes, we're going to continue the order not to have any contact with Mr. Jared Weeback. You're not to go to the address in question, which do not walk past the door. Possess no other firearms or weapons. You are not to harass, and this is a form of harassment in my view. This whole cigarette situation is harassment and intimidation. If you do any more harassment, intimidating, any assaulting, beating, molesting, wounding, or threatening of any kind of Mr. Webeck or any other witness in this matter, then your bond's gonna get snatched. And I'm gonna write that in there. Any other violations going by Webeck's apartment will result in revocation of bond. And that will be up to the circuit judge, but that is my note and my opinion on the matter, which I'm certain they will take into consideration. You are also going to have a GPS tether. Now, go nowhere except stay home, I shall say, except work, verifiable doctor appointment, and court if it's necessary to go into court that is not on Zoom. Bond is going to be increased. Right now it's at a $1,500 personal. You can't trust them on personal anymore. So that's going to be a cash or surety in there. So you need to get a surety to post this. Unless you got $15,000 cash or surety. I'll make it a 10%.
Thank you, Your Honor. And Your Honor, could you include in the visits, the attorney visits as well?
Do you have any people in your office?
Unfortunately, we've had a COVID outbreak at the office, so I've been kind of afraid to go back there, Your Honor. So I think
aren't you doing Zoom?
I am, but I have to go back in. I'm probably going to end up going back in within the week or so. I think that's when the quarantine is going to be over for the office building.
All right, I'll put verifiable. I thought about it, but I didn't because I didn't think anybody was having people in. But I'll put it in verifiable attorney visits, which means the tether people, and you must get tethered within 24 hours. So he's going to have to get it fast. All right, so therefore, if there's any other problems now, Mr. Stuckey, this is an issue. And everybody now is clear on what should and should not be done in that building. Did you have any questions?
No, ma'am.
All right. So the bond is changed to a 10% bond. He needs to get that bond as soon as possible. He also have to turn himself in, Mr. Toussaint. So he needs to be calling some seats today.
I will, Your Honor.
Okay. All right, that'll conclude this matter.
Thank you, Judge.
Thank you very much, Your Honor. Yeah, everyone stay safe.
Thanks, you too, Mr.
Thank you.
Thank you, Mr. Lubeck.